Well, good afternoon and welcome to this educational video blog around uh, legal divorce proceedings in the province of Saskatchewan in Canada and considerations for marriage and family therapists resulting from that. So there's some, generally what we're going to go through, there's the general divorce process, so we'll explain that. We'll talk about child custody and some of the legal issues around that and how MFTs should or could be involved in that. Considerations for evaluating child custody, the AAMFT Code of Ethics, and some considerations in there, and then finally some tips for releasing information if you're subpoenaed as a marriage and family therapist. So the first thing I guess I'll say by way of personal presentation is that I haven't had a lot of involvement with this. We don't, traditional marriage is not part of the community that I'm involved in as a majority. Most relationships are transient, not legally formalized. Well, it's just the nature of the community and the population that I work with. Um, so that being said, though, these are broader considerations for the province of Saskatchewan. So some of the general divorce stuff. Divorces in Saskatchewan are processed through what's called the Court of Queen's Bench, and that is the highest judicial provincial court. Judges are appointed federally to this, but it is a provincial court and it falls under provincial jurisdiction, and marriages are provincially legislated and legalized or formalized as well. So anyone who's performing a wedding, you're licensed under the province of Saskatchewan. So the divorce operates the same way. Either or both spouses can apply for a divorce based on the official term is the breakdown of marriage. And so legally, a breakdown of marriage constitutes generally one of three things. First off, if the couple has been living apart for a year, that's considered a breakdown of marriage and grounds for divorce under the law. Adultery is also considered a breakdown of marriage and reasons for divorce. And then finally, physical or mental cruelty. And it does specify that physical or mental cruelty is intolerable and basically makes it difficult or impossible for the people to live together. So that's the breakdown. In the Divorce Act in Saskatchewan, it does state that reconciliation is actually the prime duty of the court. So the prime duty isn't to necessarily facilitate the divorce, it's actually to facilitate reconciliation. And legally, they're supposed to sort of establish that it's not possible for reconciliation to occur. So technically, if the judge thought that reconciliation was possible, I think he shouldn't actually issue a divorce. I think practically speaking, I think if the couple walks in and says reconciliation's not possible, they're probably just going to go with that. But that is the legal standard. The other variation into reconciliation is that if it's clearly inappropriate, in sort of the legal language, it's clearly inappropriate for reconciliation to occur. So I guess an example of that would be, spousal battery, where someone is being repeatedly assaulted, then obviously reconciliation wouldn't be appropriate under those circumstances. It's risky for the person who's being attacked. So that's the legal sort of ramifications, I guess, if you will, the legal regulations around divorce in Saskatchewan. Other things that would come down with this if there's children involved, so the courts can issue child custody orders, and I'll talk about that a bit more in the next section. Courts can also issue child support orders, so it is possible you could have a custody situation where there's no support involved. So those would be two separate orders. And then the court can also issue a spousal support order. So in the case of one spouse being significantly financially better off, a really good job, that kind of thing, and the other spouse, either can't work or is looking after the child. And I think actually even spousal support could happen where there isn't a child. If it was a situation where the partner had been looking after their spouse financially, and there was precedent for that, then the spouse would need to continue probably providing some kind of financial support. So those are the general divorce regulations and rulings that we should be aware of as marriage and family therapists. A lot of that probably isn't going to impact our therapeutic work too much, but again, we should be aware of them and aware that they could. And certainly as things like court orders come down, that's definitely going to have an impact on people's mental health, their ability to cope with things, and that sort of thing. So, so the next topic we want to cover is child custody. In Saskatchewan, there's, again, the legal term or the legal language is that children should have, quote, maximum contact with parents. So in other words, the child should be seeing the parent as much as possible versus sort of bare minimum, right? So the standard isn't what's the least the child can see the parent. It's they're seeing them as much as possible. So variations on that, of course, would be if there was abuse involved. So there are loopholes, I guess, if you will, to that. And the court would determine what is the appropriate maximum contact, and if there was, say, a restraining order or something, the appropriate maximum contact would be none. So it doesn't mean that that they have to see the person or that the parent and child have to see each other. That's still, there's variations in that, but that's the standard or the principle is maximum contact. Another main principle is that the good of the child is primary, right? So if a parent is arguing that they really, really need the child for their own mental health, that's not really a good legal argument, particularly if it could be established that actually that was bad for the child, right? Or in our context, you might see something like, well, if I don't have my kid, I'm going to be using drugs and all this kind of stuff. Well, the child isn't responsible for keeping the parent clean and sober. So again, that wouldn't really factor into who would get custody of the child. It needs to be the good of the child is the primary concern there. As marriage and family therapists, there's a couple things to keep in mind. One is that we do think systemically, we treat systemically, right? So even though we're talking about sort of the good of the child, at least as a marriage and family therapist, I want to be thinking about that in a systemic perspective, right? Because the child isn't sort of an individual factor unimpacted by the rest of the family system. So that's something that we sort of uniquely bring as marriage and family therapists, and we should be keeping that in mind. The other thing, I guess, to keep in mind as a marriage and family therapist is that there is no one best format. So traditionally we thought, well, mom having the kid, that's best, and anything else is sort of suboptimal. And I don't think we look at it that way anymore. Certainly as marriage and family therapists, we don't look at it that way anymore. So we really need to kind of be looking at case by case, family system by family system, and advocating for what's best for the child under that, not some sort of pre-formulated idea of best case scenario sort of on a principle. The principle is each case is different and separate and needs to be considered as such. Some considerations for evaluating child custody. Again, I've already kind of mentioned that, but what is best for the child, right? That's our primary factor in here. again, we should be thinking systemically. And there could be extenuating circumstances that we need to be thinking about. So, for example, health, finances, addictions, all those kinds of things play into custody arrangements, even the neighborhood. And we've seen that in my city where if one parent was living in a safer neighborhood and one parent was living, next door to a gang house with active drug sales going on and violence on the street, those things would come into consideration for the protection of the child. So again, lots of sort of circumstances outside the family to consider. Moving on to the code of ethics and some considerations around that. So I've gone through the code here, and I'm looking at sort of some specifics. One would be informed consent. So again, making sure that people understand, excuse me, what the goal is here. So if we are helping with the divorce process, then they understand that that's what's happening, right? Within that, they understand that divorce is adversarial. Right? This is probably not going to be a completely peaceful process. It's not. People are not going to feel good about this, right? Generally, with therapy, people think, well, it's going to be all good and it's going to be all beneficial, and we're going to be gaining peace, and that might not be the case in a divorce proceeding. So people should be aware of that. Limits of confidentiality and written authorization for release of client information. Again, people should be aware that in divorce proceedings, you're probably, lawyers are probably going to be involved. The lawyers might be talking to the therapists, and so to think through ahead of time what information can and can't be shared, what information, even as a therapist, I might be asking, knowing that things could be brought up in court. So thinking through some of that confidentiality stuff, and then being able to have written records and written paper trails of that kind of thing is important too. Scope of competence is something to think about. So as I mentioned earlier, in my neighborhood, we don't see a lot of divorce. This is actually outside my realm of experience for the most part, so I would need to consider I'm probably not actually competent to help someone with this. I would probably be referring, particularly if it looked like there was going to be a lot of legal action and legal activity. There would be better marriage and family therapists out there than me to deal with this sort of thing. A couple things to think about sort of with exploitation. This is under Standard 5, more with students and supervisees. This might be a difficult kind of situation to have a supervision sort of an arrangement in. That might be something to think through and go like, maybe this isn't where we want students and supervisors working on things. There might be a way to do it. It's not something I would probably personally be comfortable with, and I would question whether or not a divorcing couple would want sort of students, in a sense, muddling around in this. Right? So sort of a caution or just something to keep in mind there. Another thing to think about under research, I don't know if there's been a lot of research done around divorcing. There probably should be. But again, there'd be a caution around protecting the research participants. This is a very vulnerable period for people. There's a lot of very difficult things happening, and so researching this would be difficult, and there should be a lot of caution exercised if anybody was going to do that. Just trying to think if there were any other. There's professional evaluations. So there is the performance of forensic services, which generally speaking we should be sort of separating therapy from forensic services. Those are potentially a conflict of interest. But yeah, I would be super careful doing that. Testimony in legal proceedings. So we want to be accurate, objective, fair, and independent is what it says in the Code of Ethics. And again, you want to be aware of it's difficult, honestly, not to take sides in some of these things, and so to make sure that you're being objective, make sure that if you're called to the stand, right? Competence is another one, and again, this is one where I would say I am not competent in this. I would not want to be doing forensic or evaluative stuff for the courts. That's not where my training lies. It's not where my expertise is. Somebody else should probably be doing that. We're just about done here. There's a couple of other things that could be looked at in there, but in the sake of time, we'll move on. The last topic here, tips for releasing information when subpoenaed. A big one would be maintaining your paper trail, so making sure that your documentation is all in order, and all that sort of thing. Second would be maintaining communication, so if you're subpoenaed, letting your clients know, so open communication between the clients and the courts and all that kind of stuff. And I guess the last tip that I would just suggest is assume that you're going to be subpoenaed. So work with that in mind, that this is likely to happen, and then you're ready for it. If you think it's not going to happen and it does, you're probably going to be blindsided and unprepared. So I would work under the assumption that I'm going to end up in court and need to present that way. So that is the considerations for a marriage and family therapist involved in legal and divorce proceedings in Saskatchewan. Thank you very much.